Based on the research made by ECPAT International on 60 countries around the world in 2019, Malaysia is ranked 23rd in line to respond of child abuse. In another statistic shown by UN Dispatch, which is the United Nations news and commentary website, Malaysia has scored 53.4% on representing the best environment for children. On the other hand, the UK has scored 82.7% in the same category. Now, this has made us question ourselves whether the law in Malaysia is adequate compared to the law in the UK in regards to child sexual offences. My name is Aiman, and today my groupmate and I will be addressing this question into three parts. Firstly, we will look into the comparison between the Malaysian Penal Code and Malaysian Sexual Offences Against Children Act 2017 with the UK Sexual Offences Act 2003. Secondly, based on that, we will then critically evaluate the adequacy of the protection provided for sexual offences against children in both legislation. Ultimately, we shall conclude this presentation on why Malaysia provides a more adequate and efficient provision in the issue of sexual offences against children up to a certain degree.
Hello, I'm Itong, and I'm going to compare between the Penal Code and the Sexual Offences Act 2003 with regards to the law of child sexual abuse. Section 375 of the Penal Code imposes offence to any man that has committed rape, which is sexual intercourse with a woman falling into any one of the 7 descriptions listed in subsection A to G. The focus will be put on section 375G, a strict liability of rape if a man has sexual intercourse with a woman under the age of 16 years old. As for the position in England, section 5 of the Sexual Offences Act 2003 protects children under the age of 13 against the act of rape. According to R&G 2006, law could emphasise that at common law, a girl under 13 cannot consent to sexual intercourse. When doubts arise with regards to the age of the victim, Section 9 of the same Act covers the victim aged 16 or below, and the elements of rape is included in Section 9 subsection 2, making it clear that it provides an alternative offence against child under 16, where consent is still irrelevant in this context. According to R and Coty 1984, there are 2 separate offences in Section 9 because the maximum sentence differs depending on whether the act was penetrative or non-penetrative. Section 377A of the Penal Code covers the loophole created by rape under Section 375, where it covers penetration of the anus or the mouth by penis. This means that the offender will be a man, and the victim can be either a boy or a girl. It must be taken note that Section 90C applies, meaning the victim is under the age of 12, consent is irrelevant, and if there was no consent provided, the punishment provided under Section 377C applies. In addition, the protection of child from sexual abuses by family members are enshrined under the Penal Code through Section 376A. Incest is committed if a person has sexual intercourse with another person which is forbidden by law, religion, and law. On the other hand, Section 25 of the SOA 2003 specifically focuses on sexual activity with a child family member under the age of 18 or the child under 13, and the relationship between the offender and the victim must fall within Section 27. Besides, inciting a child family member to engage in sexual activity is as well an offence under Section 26 of the same Act, where person A intentionally incites another person B to touch or allow himself to be touched by A. The Penal Code provides a wider protection as the lists provided are not exhaustive compared to SOA 2003, and the punishment will be aggravated if rape is present as provided under Section 3763, subsection 3. However, the SOA 2003 has positioned the age of the victim to be below 18, a little higher compared to the Penal Code. The lacuna in the Penal Code is that according to Lecken, Gurrick and PP, Section 376A only provides offences limited to vaginal sexual intercourse, but not other forms of incestuous relationships like how the SOA covers by introducing the elements of assault by penetration. Moreover, the issue of consent should not be a defence for incest, as children up to 18 might not be able to make choices on sexual partners in a mature manner, and as they highly depend on their family members. The Penal Code further protects children under Section 377CA of the Penal Code through sexual connection by object. A person, regardless of it being a man or a woman, would be guilty if he or she introduces any object into the anus or the vagina of the person, and of course, without the consent of the person. Consent is irrelevant again under Section 90C of the Penal Code. For the UK position, this is covered under Section 6 of the SOA, which is assault of a child under 13 by penetration, and is basically the same as the Malaysian position, where consent is as well irrelevant in this provision. However, the UK provision extends the protection to children below 16, which falls back to Section 9 of the same Act under subsection 2A. In comparison, the Penal Code automatically negates the issue of consent under Section 90C, but not for children above 12, proving it to be provide a narrower protection as compared to the UK provision for assault by penetration. Under Section 377E of the Penal Code, it is an offence to incite a child under the age of 14 to an act of gross indecency. The question that arises is, what is the definition of gross indecency? The definition of gross indecency is, there is no provision in the Penal Code that defines what constitutes gross indecency. But in Sukma Darmawan Sarmin Taat Manja and Ketua Pengarah Penjara Malaysia and another, the Chief Justice of Malaysia, Yusof Chin, stated as what act constitutes to indecency or gross indecency. The legislature itself has seen it fit not to give it a definition, but has left it entirely to the court to determine. On the other hand, Section 10 of the SOA provides for an offence to cause or incite a child, and the elements are similar as compared to Section 9. It could be observed that Malaysia's Penal Code provides a wider scope of protection, as gross indecency is not anyhow defined under the Penal Code, and it is decided based on a case-by-case basis.
I will start off by laying down the application of legislation provided in both of these countries. It will continue with the scope of legislation and other various actionable variables that we cannot exclude. It will then critically be broken down into segments so we can make in-depth comparison of the similarities and differences in Malaysian and the UK positions. Provision in accordance with Sexual Offences Against Children Act can be seen in the most recent legislation of Sexual Offences Act Against Children in 2017 was implemented specifically to protect children in Malaysia. Prior to this implementation, laws governing child sexual offences are very weak. One of the most notable lacunas that was witnessed by many is in the case of Richard Hako, which can be said to be the trigger for Malaysia to improve on its legislation. This had led to Section 3 of SOACA to take effect of extraterritorial application to any citizen of Malaysia, no matter where he had committed the offence. Section 2 then states the application of SOACA shall be applied to children under the age of 18 or the perpetrator believed that such a child was under the age of 18. The Act has been made to tackle the issue that was left as a lacuna in the law post-Richard Hako. It had also taken into consideration of technology, social norms, practice of the pedophiles, which had made the law more wholesome and holistic when it comes to protecting children. When SOACA and English Sexual Offences Act 2003 were compared closely, a huge distinction can be drawn. What the legislation of SOACA provides include the issue of child pornography, child grooming, physical and non-physical sexual assault, and on the other hand, the UK had proper legislation pertaining to child grooming, physical and non-physical sexual assault. There are very little detailed provision in prohibiting child pornography. Malaysian SOACA had also focused heavily on the issue of child pornography. The definition in Section 4 therefore states any audio, visual, written or any combination between this child is engaged in sexually explicit conduct, or any adult who appears to be a child, and that or any realistic representation of sexual explicit conduct will be deemed as a child pornography. The UK provision that was responsible for child pornography is in the Protection of Children Act 1978. This act was made back then and had only covered distribution, publication and possession of these photographs described in Section 1. The Malaysian SOACA had also taken a step further to not only base on the action as a result crime, but a conduct crime. The Malaysian Act had not only restricted the conduct on distribution, publication and possession. Section 5 states that making and producing of child pornography. Section 6 is about preparation to commit Section 5, and Section 7 uses a child for the purpose of Section 5 is prohibited. It is eminent that although Malaysia had adopted such section from UK, Distinction can be drawn to the extra steps mentioned above. However, the similarities of SOACA had also been prohibition and of exchanging, publishing, selling and accessing of such content under Section 8, 9 and 10. If comparisons were to carry out on the English legislation, these are the differences that was made and similarities. Malaysia had also addressed the issue of child grooming that was lack of presence before the implementation of SOACA. There was no relevant laws in addressing the issue of child grooming prior to SOACA, which can only be based on limited approach in the penal code that my friends have talked about. This poses a serious issue until 2016, where the report of child sexual harassment in 2016 alone is a staggering case of 12,000 was reported and only 2,000 was filed and 140 was convicted, while English Sexual Offences Act 2003 had efficiently covered the issue of child grooming. In Section 15, it states that a person shall be deemed guilty when a person 18 or older with the intention to meet and communicate with another person below the age of 16 or does not reasonably believe that the person should be 16 or above on 2 or more occasions with the intention of committing any offences stated in subsection 2b is said to be guilty of the act of child grooming. Malaysia seems to approach the issue similarly in SOACA, taking steps in laying down the characteristics of sexual communication with a child, and in addition to that, Section 30 defines child grooming in which summarizes any person communicating with a child with the intention to commit offences listed down. It need not be a result crime. Malaysia SOACA would then take a step further to emphasize on intentional steps from meeting a child after communication is made and would receive a much severe punishment. Finally, we will proceed to the person in relationship of trust and abuse of the position of trust. The UK legislation had effectively construed a total 9 sections, while Malaysia SOACA had only mentioned it in 1 section, which is Section 17. Even though on prima facie, the UK provisions may be more thorough, upon close examination, it reveals that SOACA may be as widely applicable as the position laid down in Sexual Offences Act 2003 in the UK position.
The SOACA also provides coverage on physical as well as non-physical sexual assault towards children. Pursuant to Section 14, it would be a crime under this SOACA if the accused touches a child or persuades the child to touch himself or the accused or anyone else. In deciding what constitutes as touching, the subjective test would be applied under which the court may take into account inter alia the part of the body that was previously touched, the nature of it, and the degree of the act of touching, and all other circumstances concerning the conduct. Similarly, in the UK, Section 9 of the Sexual Offences Act 2003 provides similar provision in light of physical sexual assault, in which this section mentioned an adult sexually touching as well as performing penetration into the minor's anus, mouth or vagina with any part of the offender's body. Section 10 of the same Act extended the coverage of the offence as it includes the situation where the offender is causing or citing the minor to engage in sexual activity. Therefore, Section 14 of the SOACA, if it's closely compared to the Section 9 and Section 10 of the UK Sexual Offences Act, the scope of protection is fairly similar. However, there is a difference between these acts. For instance, in Section 14 of SOACA, it did not mention on the act of penetration towards the child, whereas both of the Section 9 and 10 of the UK Sexual Offences Act do specify such circumstances. As far as non-physical sexual assault against children is concerned, it is protected under Section 15 of SOACA, which is fairly extensive. However, it may be summarized in 4 points. Firstly, a person may be guilty under this section if he makes any lewd sound, gesture, or expose body parts that are intended to be seen or heard by the child. Secondly, exhibiting the child's body or part of the body to others. Thirdly, constantly following, watching or contacting a child. And lastly, showing or involving a child in something that is sexual, which also include exposing pornographic content towards the child. Relatively, these angles of protection are also covered in the UK law, as it is laid out in Section 11, 12, 14, 15 and 15A of the UK Sexual Offences Act. Section 11 stated that a person may be convicted under this section when the act of the sexual engagement is done with the presence of a child, and Section 12 laid out that when a person may be convicted if he is causing a child to watch any sexual activity. Additionally, Section 14 stated the act of facilitating commission of a child sexual offence, and Section 15A of the Act also provide provision in a circumstance where a person communicates sexually with a child. Lastly, Section 15 is regarding child grooming, which is already mentioned by Ethan. All of these sections that were mentioned require the intention of the person performing such act to obtain sexual gratification in order for him to be convicted under one of these sections. Thus, by analysing both of these SUAKA and Sexual Offences Act 2003 in regards to non-physical sexual offences against children side by side, both of the Act provide similar protection. Now, let's move on to the next part, which is the evaluation of the adequacy of the laws.
My name is Zafa Farouk, and I will be elaborating on the adequacies of law in UK. When examining the law of UK in relation to child sexual offences, it is notable to point the evolution of laws that are implemented today. Important reforms were seen in Sexual Offences Act 1956 and Sexual Offences Act 2003. For example, in the case of Crown and J, the House of Lords enlarged the scope of the time limit for prosecutions for underage but consensual sexual intercourse under Sexual Offences Act 1956. Lord Roger recognized that there may indeed be some initial difficulties resulting from the majority opinion. The problem in Crown and J concerned proceedings for unlawful sexual intercourse under Sexual Offences Act 1956. Section 6, which had to commence within 12 months of the offence charged. The time limit had to be interpreted to apply to acts of intercourse when charged under Section 14.2. The time limit problem, however, only arises in Sexual Offences Act 1956 because there are no time limits in Sexual Offences Act 2003. However, the issue to be highlighted here is that Sexual Offences Act 1956 still applies in relation to all acts perpetrated before 1st May 2004. And given the long delay which typifies the reporting of many sexual offences against young victims, its interpretation will remain a cause of concern for years. Furthermore, a review of the law in relation to sexual offences culminated in Sexual Offences Act 2003. Legislation that dramatically altered the legal landscape relating to sexual offences generally and the offence of rape specifically. In the United Kingdom, Section 72 of the Sexual Offences Act 2003 deems a British citizen or UK resident to have committed sexual offences against a child under 16 in England and Wales and Northern Ireland despite it was committed overseas. However, it is important to highlight that the provision requires a double criminality, that the act does not only amount to a sexual offence listed in Schedule 2 to the Act, but must also constitute an offence in the country where it was committed, irrespective of the different descriptions of the offence in both countries. Provision in convicting a child sexual offender is the case of Richard Huckle that had become a national uproar in 2016. Richard Huckle has been convicted in London for 71 sexual offences that involved, among others, Malaysian child victim. Sexual Offences Act 2003 was generally sound. There were issues about understanding, interpretation, and implementation of legislation. In particular, the report of Parliamentary Inquiry into the Effectiveness of Legislation for Tackling Child Sexual Exploitation and Trafficking within the UK highlighted that there was no specific offence of child sexual exploitation. Instead, prosecutions were brought on a range of offences such as sexual assault, rape, and other sexual offences against children under 13, meeting a child, following sexual grooming, causing or inciting a child prostitution or pornography, and trafficking within UK for sexual exploitation. Amendments to the legislation were recommended to allow legislation to capture child sexual exploitation.
Therefore, it is outstanding that the laws of Malaysia are adequate to a certain extent to combat sexual offences against children in Malaysia. The SUAKA 2017 is clear in illegalizing all forms of child pornography, including the production of such materials and its distribution. Apart from child pornography, the SUAKA 2017 created the offence of child sexual grooming, which consists of the preliminary acts leading to the actual perpetration of child sexual exploitation. To further amplify the impact, any meeting subsequent to grooming is made a separate offence in Section 13 of the SUAKA 2017. These reforms are applauded by the public as it assists the prosecution against such offenders. To an extent, these laws are more comprehensive than our neighboring countries such as Thailand and Cambodia. However, it can be argued that these laws are not extensive enough to cover all forms of devices. Most material and communication on devices involving a child victim may be deleted and not necessarily be permanent enough to be produced as evidence in court. Despite having these laws, advanced technologies to combat the dark web and other websites are not initiated or employed by the government to combat child sexual offenders. As the cyber world has no definite territorial boundary, and where the act of child sexual exploitation involves a child victim in Malaysia, the question arises on the issue of jurisdiction. For example, Richard Huckle's case was convenient in the sense that UK laws has adequate enforcement of the Sexual Act 2015. Section 3 essentially allows the Malaysian courts to exert extraterritorial jurisdiction to prosecute a Malaysian offender who has violated the SUAKA even abroad. The provision does not only cover the offences under the SUAKA 2017, but also other offences listed in Schedule 2 to the Act that include those crimes related to child sexual exploitation under Section 43 of the Child Act 2001 and child trafficking for sexual exploitation under Section 14 of the Artipsom 2007. Nonetheless, there remains a loophole in the law of Malaysian jurisdiction as to the location of where the crime was initiated. As Section 3 of the SUAKA merely punishes Malaysian citizens but not foreign offenders. For example, Thailand laws do not illegalize sexual communication with children. In such a situation, the lacunae in our law to exert jurisdiction over such crimes provide a platform for perpetrators to victimize children in Malaysia. Finally, the Malaysian court's approach to sentencing for sexual offences against children has undergone various trends in the judge's deliberation of deciding the fate of the convicted. The SUAKA 2017 clearly states the details of punishments, which aims as a deterrence and rehabilitative support to offenders. However, it fails to address the needs of the child victims to support programs contained in other related legislation such as rehabilitation, counselling, and even compensation. In addition, the Malaysian legislation should be applauded for their reforms in the Criminal Procedures Code, which hands out the punishment for statutory rape cases under Section 395 of the Penal Code. Following the controversial case of Noor Afizal against PP, where the 25-year-old offender was given a bond of good behaviour by the judge, which followed a series of cases which handed out rehabilitation programs instead of harsher sentences such as imprisonment. Similarly, Angeline Lau's research shows that although the maximum term of imprisonment is provided statutorily, it is rarely that judges handed out maximum sentences against offenders. These outcries led to the reform of Section 294 of the Criminal Procedure Code, which effectively removes the discretion of the judge to grant a bond of good behaviour to sexual offenders. Finally, sexual offences against children is a great matter of public interest, and it's heartening to see that judges take into consideration of that doctrine when sentencing perpetrators. In the case of Jamaluddin B. Khadiron against PP in 2004, the appellant had pleaded guilty to an offence of attempted rape on a 10-year-old child. He was first sentenced to 5 years imprisonment and 2 strokes of baton. On appeal, however, the court was on the view that the sentence was inadequate on the ground that public interest must be taken into consideration in respect of these type of cases. Furthermore, the establishment of the special court in the Palace of Justice exclusively dealing with sexual offences against children is seen as an initiative by the government to highlight and combat the crime. It also displays the value placed by the Malaysian legislation on these abhorrent acts which has plagued the countries. Despite these measures undertaken by both the legislation and court system, it is regrettable that statistics show that the rate of rape cases is still quite high. In 2017 alone, there were already 1,878 cases with the highest percentage of victims, which is 49%, consisting of girls aged 13 to 15. Therefore, statutory rape still remains one of the highest sexual offences in Malaysia. Thank you.